Yeah, well, I mean, thank you for attending this meeting of Banks and Banking. We'll call the meeting to order, and I would ask Chairman Nix if he would give our invocation. What's your number?
Number 17. Let's pray. Father, we thank you for this beautiful day and for your blessings to us. Just pray now that you would be with us and give us the knowledge and understanding we need as we look at these matters, that we would do the things that be pleasing to you. In Jesus' name, amen.
Thank you, Preacher. Okay, at this point, we will recognize the author of House Bill 465 to explain his bill, Chairman Martin. You may proceed. Yeah, I don't know which one it is, so this is at 2.
Mm-hmm.
Mr. Chairman, I would be working today from LC 390450 ERS. If that please the chair and the committee. I know it's the hour's late. It's a significant bill, I think 14 or 15 pages, so I want to give it its due. We tried to get the substitute out to a number of interested parties today, so if the chair will guide me in terms of the detail he would like me to cover, I will try to go appropriately.
Why don't you give whatever you feel like aptly explains the gist of the bill, and then we'll allow the committee to ask questions that would be relevant to learning
that would be
content.
Good. Well, Mr. Chairman, what we're seeking to do is to protect our consumers but allow them to have a service provided, and we're defining that as debt management service. We want those providers to be regulated. The bill currently calls for that to be done under the banking department. I know there's been some question and some concern by people that I've talked that this process is happening in other states, and if you will, the bad actors in the business try to do something like this. Is if you're in debt settlement, or if you would like us to settle your debts, is give them over to us, and if you have a debt of X, we'll get that cut down to 2/3 of X or half of X or 80% of X, and give us some money up front here, and we'll get that done for you, and you'll be better off as a consumer. And we didn't think that was the way to go in this bill. So if one is going to enter into a debt management service where the principal amount is the goal to have that reduced, there can be no fee charged until a negotiated agreement has been had. In other words, there's not going to be a situation where we work real hard for you. We get money up front, and then we come back and say, we did everything we could, but we couldn't help you out. We couldn't reduce your debt. You have to go and find some other avenue. So I think one of the key things for the committee to look at is we've tried to keep this very consumer friendly, so it can work on debt, management services, debt settlement services, and the fees that are charged are for results. We've tried to put in the regulation. I can step through the sections of the bill, but we've tried to put in definitions and regulations so that our consumers are protected, so that our consumers have the ability to cancel within 7 days, so that monies that are held by a provider have to be accounted for and reported on at least on a monthly basis. I'm sure I can go into some exclusions of people that aren't required, that can be in the business today, that aren't required to be re-regulated, but also areas where we've tightened it up so that anyone providing the service in the state of Georgia to a Georgia consumer must be registered to do business under this law, whether they do it for profit or not. The bill talks about the provider not being able to take an equity interest in a consumer's property. In other words, they can't settle your debt and then you in fact become in debt to the provider for a larger amount. So we've tried to do it with the eye on consumer protection. Mr. Chairman, again, I can step. It's easier for me at this late hour when you get my age to step through the bill section by section and tell you exactly what it does. But the brief overview is to allow for more people to be in this business, but have them regulated so it's competitive, and Georgians can have these services available on a competitive, even playing field.
So you're saying that's what would be true the day after the governor signs the bill,
Well,
is that
it is my goal, and I think this bill takes steps to having more providers available to Georgians with competitive fees so that they would be in a better place. Yes, sir.
expanding debt management services, yet
expanding
regulating it.
Expanding it, yet regulating it. It does. I mean, I heard someone talk about it. It doesn't cap a fee. It does not. But providing more service providers lets the market regulate the fees. What it does say is you cannot charge that fee until you perform a service. It doesn't allow for any upfront fees.
Chairman Nix has a question for the author.
Yes, thank you, Mr. Chairman. Just a question up front. This is a very busy bill as you look at all the new language that's being added. I'm curious as to why we would be hearing this late in the session. Did we just think of this?
Did we just think of it? I don't know that we just thought of it. I mean, we've had the bill in for a number of days. We actually have had the bill redone on several times. I've asked for changes to be made to get it more consumer, what I consider to be, more consumer friendly. Certainly is, a great deal of language, but I would refer the gentleman, and I don't think I have it with me. Actually, maybe I do. Current language that regulates this industry is about 3 pages. So we're actually providing quite a bit more consumer protection than is currently in the code when we build in the new Chapter 5.
Okay, thank you.
Can't tell. Oh,
Thank you, Mr. Chair.
proceed, sir.
Thank you. Right here, I have a question
Oh, there
for
you
you.
go. Yes,
Thank you
sir.
so
Mr.
much.
Smith.
With this substitute, HB 465, can you explain so that a common layman could understand the benefits for businesses and the businesses for consumers with this substitute?
Well, I mean, businesses, the provider, or businesses that are creditors.
Mm-hmm.
Which one?
Businesses for providers first, and then the consumers, which are the actual creditors. Which would be the benefits?
Well, I think there's two. I think that when I said the creditors, I was the people extending the credit as opposed to the people that are actually
those are the
receiving
businesses.
it. So you're looking for the business of the providers. I
Yes.
think benefit here because they have a defined playing field. They have certain regulations that they have to abide by in order to do business in the state, and they can actually do a form of the credit management debt settlement that's not allowed actually in the state now because of the fee structure. It's just a service that can't be provided given the current fee structure. So you broaden the base of providers that would be available to our consumers. Our consumers benefit, in my opinion, for having that opportunity to choose what type of debt settlement service they would like, and they have the ability, they have the protection that they can't be charged by Georgia law until they actually receive a service. Chairman Willard worked with us on language in the bill that has to be bold-faced and initial, that talks to the provider, which is the person extending this service to them, to the person that is in debt and is looking for a settlement service, whereby they have to be specifically told that there are other ways to settle your debt other than debt settlement or debt management. It specifically says a bankruptcy is an option. That's not an option that people want to have. But we've tried to put significant consumer protections in, broaden the base of providers, and by doing so, create a competitive business field so that consumers would be able to avail themselves of more quality firms to provide the service.
Thank you.
Thank you, Representative Smith. Chairman Hill.
Thank you very much, Mr. Chairman. Thank you very much, Chairman Martin, for bringing this bill. But I want to make sure that it goes through as intended. And I noticed that back in the definition section on line 116, section C, it defines a provider. Excuse me, but for the definitions is prior to that. The definitions on line 62, the top of page 3, defines a provider as a person. And everywhere else, the provider is referred to as an entity and having people under that. And I wonder if you might want to look at redefining a provider, because it is not really, it may be a person, but everywhere else it goes into a lot of other requests. And you might want to change that definition to make it applicable throughout the rest of the bill. And I'm not an attorney, I'm not sure if you want to just make that means a person or legal entity or some wording such as that. But
yes, sir. Chairman Hill, I'll absolutely take that under advisement, and I would yield to a legal opinion on that as to if person, the way it's defined in that chapter, refers to a single individual or could refer to a corporate entity as well. I appreciate the gentleman. I also, as I mentioned to the chairman, we have, actually in process some additional definitions that goes in the bill, and it goes back to what Nick said, that we are trying to do this quickly because we think that it does provide additional protections to Georgia consumers, and we would like to try to move it through the process and have a discussion to perfect the legislation that just moves forward so that we get it in, a year and allow.
And that is my intention, to help you perfect it so it goes through and goes through well.
Open to that.
Representative Flood.
Thank you, Mr. Chairman. Chairman Martin, I think this bill probably came to this committee last year, if I recall, with a number of questions. And I see that there's a great deal of language as to the protections that you described as consumer-oriented protections. But I'd like for you to explain, it's sort of in the spectrum of consumer options, whether it be bankruptcy or credit management. Where does debt management, where does this fit in the range of options that a consumer might have today?
Well, I must admit, and I'm glad I've not been in the situation to be a consumer of this product, but I think that if I were to give someone advice, I would think you would try to avoid bankruptcy at most all costs, unless the debts were exceeding something that one couldn't overcome. I mean, I won't presume to give that advice as an individual here today, but I think this is a debt management services is something that one would enter into for a number of reasons, not the least of which could be, debts coming from different directions, creditors calling and looking for a debt, some sort of a debt consolidation. As to where one would enter into what is commonly referred to, I think, as a debt settlement, where you would accommodate or accumulate the debts and go to your creditors and say, we can develop a plan where, with a one-time payoff, we'll get you your money, and that'll be for X dollar, pennies on the dollar, and you'll agree to that, and it won't, hurt an individual's credit, or whether it's a credit management situation where the principal amount is not reduced, but you somehow aggregate the debts and create a payment plan. I think that's something that each individual consumer needs to be walked through, and there's portions in the bill that talk just to that, that a provider under this bill has to provide that type of conversation with a consumer to give them the options of, is it best to go forward where one is trying to reduce a principal amount and go for a debt settlement type, or a debt management program where one does not seek to reduce the settlement amount, but instead may consolidate the debts and have help in being focused on getting those debts paid off. I mean, we've always heard that. I mean, you hear things with consumer advisors on TV that say, pick a debt and get that one paid off and then go to the next one. I think some of the credit management and the consumer credit counseling, lowercase, I would use those words, that may be an actual company that does that, but in generic terms, I think those are the things that this bill requires a provider in this business to talk to a consumer about and find out for them what is the best product for them. I couldn't sit here today and tell you that if your debt is between this amount and this amount, you should go option A, because I don't think that's a specific path one should take.
But one final question, Mr. Chair. Your presentation on this was really focused on consumer protections. Are there consumer protection organizations that are supporting, sponsoring, speaking on behalf of the bill?
I do not know. I've talked to a number of people today that had questions about the bill. We tried to get the bill to everyone that had a question. I would not know. I do know that one group, the feedback, and we were on the floor all day, as the representative knows, but one of the groups that had questions this morning about the consumer protections was under the impression that the bill would still, as it does or as the industry works in other states, allow upfront fees that could be paid and when no service was done. I think they were a bit more comfortable when they found out that no fee could be collected until there was actually an agreement achieved, but I would let them speak to the bill directly themselves.
Thank you.
Representative Frazier.
Thank you, Chairman Morris. Chairman Martin, I really haven't had time to go through this. As a rather lengthy bill. However, I do have a couple of questions as it relates to the code here. Is this considered a revision of the Title 18 code? Because this bill, as you stated, the current legislation was only 3 pages. This is significantly more. So is this like a rewrite of the current debt management that we have currently for consumers?
Yes, ma'am. This would replace Chapter 5 in its entirety.
And is that a need that we need to do? Because I understand, just listening at you now, that we're only doing this to allow for other providers to opt into this service. So why couldn't they opt into the old code?
Well, I think we're providing additional consumer protections even for those that would be in the business today. And what we're trying to do is keep a standard provision and delineate the, debt settlement from debt management with the terms of if one is reducing principal or not, because that's how typically you get earn a fee in a different manner. But we wanted all of the providers to be treated the same because, again, Representative Frazier, one is a debt management service provider. You shouldn't have a preconceived notion when a consumer comes in your door, do they need debt settlement or do they need debt management services? One should provide them the options that would fit them. You shouldn't hang a shingle, in my opinion, you shouldn't hang a shingle out there and say, I'm a debt manager, I'm a debt settler. You should provide those services for a consumer and let the consumer choose what's best for them, through the education process. So to answer your question, the reason we redid the chapter is to have all of the regulation and the consumer protections spread equally across the business, whichever type of service you're providing.
And so currently that is not being done.
It is my opinion, and I can have some copies made of the current Chapter 5. I do not believe there's near the consumer protections in the current Chapter 5 as would be in place should this be moved forward.
Thank you.
Representative Douglas.
Yes, I have a couple questions. Thank you, Chairman. I'm just take a look at, based on what I've heard recently, I've been in the mortgage field for a time now.
Right.
And what you're telling me is that based on consumer credit counseling, which is a debt collector for agency, you're saying this broadens the scope of more debt collectors offering services to.
No, Representative Douglas, and maybe I misspoke. When I said consumer credit counseling, that's why I said lowercase. I don't mean to put that if there's a company that does debt collection based on that name. I didn't mean to infer that. What I think of the credit counseling is, sometimes you're on the news channels and they come on there, or there's a show on Saturday morning, I think on one of the financial channels, where there's a lady on there that talks about, how to manage your debt, whether it's you're a person just starting out or you're a retired person, whatever, that they, give you ideas about if you've gotten overextended, things to do. Pick a credit card, pay it off first, consolidate your debts, get a lower interest rate, pay the things with the highest interest rate first. Those, to me, are sort of consumer credit, opportunities. What I meant to say was this bill would allow for debt settlement. I don't think debt settlement can really be done in Georgia based on the fees that are allowed in the current Chapter 5. So that's really not an option for our consumers in Georgia. And I'm not going to sit here today and tell you that there may not be some people that testify and testify today and tell you they don't like debt settlement. That they could be right for some people. I can't sit here today and tell you that debt settlement, which is the seeking to reduce the principal one owes, is certainly not right for everyone. But I think, for Georgia to offer all those opportunities, as long as the consumer is protected, I think each individual Georgian should be able to decide what is the best way for them if they've gotten themselves in an overextended situation.
Okay. Another quick question,
Yes,
if
sir.
I may allow. In the mortgage field, consumer credit counseling, which this falls in the same ramifications as consumer credit counseling people, it's the same jargon with more criteria. In a mortgage person's eyes, this is just like filing Chapter 13. The way we look at it, when you go buy a house, if you've been through any kind of consumer credit counseling, it's looked at as being a Chapter 13 across the board. So I think this allows for more companies to come in and say, okay, we're going to settle your debt at a cheaper rate than the current companies are. Is that correct?
Well, when you say at a different rate, I mean you mean at a different principal amount, at a reduced principal. If I were to owe you $10,000 and I have a company comes in and negotiates that down to $5,000.
Right.
Yeah, sir, I'm not in the mortgage business. I don't know how the mortgage banking business would treat that on your credit report. I can't honestly tell you, but I believe what you're telling me is if one had to come in and fill out a mortgage loan and they were to have to disclose that they had been through a debt settlement whereby a principal amount had been reduced, they would have to disclose that, and that would somehow affect their ability to do business going forward with a mortgage. And I appreciate you bringing that point up, because that's very important in that's exactly something that I, as an author of the bill, I didn't know, but is something that they would be required under this bill to disclose to a consumer before entering into a debt settlement agreement with them. They have to educate them and disclose to them all the ramifications of going down that road. That's why I said just because debt settlement would be allowed under this bill, it doesn't say that, what percentage of Georgians or a majority of Georgians might go in that direction.
All right, another quick question. Who pays the fee? Let's say you come in and do you charge that fee? Is that fee rolled over to the client, or does the credit agency who's collecting for the creditor, do they encompass the fee?
As this bill is written, the provider, if one is seeking to reduce the principal, if a provider is seeking to reduce the principal, that fee is agreed upon between that provider and the consumer prior to the settlement being achieved.
Okay, is that on the total amount, or is that on the fee that's already negotiated down?
Well, the agreement would, I will let some of the people testify, but as I understand it, it would be, I have a debt of X. I have a debt of $10,000, and I'm going to enter into a deal with you to settle that for me. And I've had everything disclosed, and I determined that's the best way to go, so that I'm going to enter into an agreement that's going to pay you a percentage of that reduction. So if you get my debt from $10,000 to $5,000, then your fee is going to be a percentage of that.
Okay.
That fee is not set in the bill. It's not limited in the bill, but it very much has to be disclosed in the agreement. And the bill also calls for that standard agreement to be put in front of the client and initialed. It also requires that agreement to be on file with the department, each provider's standard agreement, so one can't hide the ball, if you will. It further says that if you normally converse with that client in a foreign language, that the agreement has to be provided in that language.
Okay. Questions into testimony?
Thank you.
Thank you, Mr. Chairman. My question goes to page 12, basically starting with line 400, but specifically on line 403, where it says at least one payment, they cannot collect a fee until at least one payment has been made towards the settlement. And my question would be is, do they get all of the fee at that time after making one payment, or do they get a portion of the fee, or how many fees, or how many debt do they have to make payments before they can get a fee?
That's a good question. The fee would be earned when the first payment is made off after an agreement had been obtained to reduce the principal amount, because the gentleman is referring to lines 400 through 405 under F, and that is to handle if the settlement is for debts that lower principal amounts. And to answer the gentleman's question, the fee would be earned as called for in the agreement.
Well, does that mean you could get all of it if after you make one payment, you could get all the fee?
If that's the agreement that the consumer entered into, yes, sir. Because again, you look at it like this. Let's just assume that I were to negotiate a fee or negotiate a reduction. In the case that I would owe $10,000, and someone found me or negotiated a debt settlement to get that number down to $5,000, you would earn that fee when that agreement had taken place and you made the first payment on that, if it were 5 payments of $1,000, because at that point the debt settlement company would have negotiated you a fee, a settlement that you agreed to and you agreed you could pay, and at that point in time they can't require you to pay the rest of those payments, but they had done that job and gotten a settlement for you that you were agreeable to and you signed off on. So again, the consumer would be in a position that if they brought them back a reduction from $10,000 to $5,000, but it said that they had to pay that in 5 equal payments of $1,000 over the next 5 months, if the consumer thought they couldn't do that, they wouldn't sign off on that. Therefore, there would be no settlement. Therefore, there would be no fee due.
Let me also point out that once the chairman is finished with his presentation, we will hear witnesses, but we're not going to question all of the witnesses, just so there wasn't any misunderstanding. So if you have any questions, there's the man. Who's next? Chairman Hill, do you have another?
Okay. Yes, I do, Mr. Chairman. Thank you again. And I thought I had it all clear, but the more I read it, I think we've got some combinations of language in here. For example, on line 384 at the top of page 12, at the very beginning, it says that no fee or charge shall be imposed until the consumer's entered into a debt management service agreement. Yet down on line 414, further down at the bottom of the page, it says if the consumer does not enter into a debt management service agreement, the provider may receive a fee of $100 and some additional language. So we've got some real conflicts. In one place it says you shall not do a fee. In another place it says you can do a fee for doing just the opposite there for $100. And like I said, the more I read this fee, there appears to be a lot of conflicts, and I think I'm getting more confused as time goes on.
If I could, and I'll perhaps I can get with the committee members as the testimony in the interest of time, but I think what we're dealing with, Chairman Hill, is at the top, if there's no fee, if there's not a debt management services, there's not one created, and it goes down into D, E, and F, and talks about that. We actually have some additional language that I asked for in the bill that we're in the process of the substitute, Chair Morris, to make clear that a provider can never be paid for negotiating the same settlement twice. And going back to the gentleman's question of if you didn't make good on all your payments, and therefore that settlement went away even though a consumer agreed to it, if they came back to the provider and said, look, I made 2 of those payments but not 3, we got to redo this thing again, the provider can't charge them again for that fee. They have to do that for the original fee. But to answer your question, Chairman Hill, I think when you get down to H, it says if you decided not to do business with us at all, the provider may receive a fee for counseling and education services, provided they may receive that fee, but they're not really into an agreement. This is basically for the education portion of it. It doesn't prohibit them from doing that, but certainly if there's no agreement signed with the customer, there'll be no remuneration done for the education.
Well, I would agree that's what I think it should be, but H specifically states that they can collect a fee of $100 for not doing anything.
No, well, no.
I mean, for providing the counseling, but then they're required to provide counseling just to talk to the person. I mean, it's very confusing because it does contradict itself a couple times, and I'm trying to clarify it so we can
and I
move
understand.
on.
And you're correct in that there's a difference between providing the counseling and entering into a formal debt management service agreement where work is done with the creditor. And it says they may receive a fee from that, but, they don't have to if that's, in other words, they can create their business in a manner that would allow them to receive that fee but not require the person to do that.
I would want to do that, except line 266, it describes it, mandates it because it uses the word shall, not may.
It does. It says
and that's why I'm very confused.
You're correct. It says they shall provide the service, but they may receive a fee.
The distinction you're saying is shall provide service.
They have to provide the service. They may
receive the fee. Chairman Hill?
Okay, that's true, but they have to provide it, but then, and in a perfect world, we'd have all good, legitimate customers and providers, but this way, a provider could collect a fee of $100 if...
I believe, Mr. Chairman, not to confuse it, not to take issue. I know you're trying to help get to the point, and I appreciate that in the perfection process, but I believe this is a place where one of these providers could offer these educational services to a group of people that don't intend to enter into the credit management services, just as an educational, and they may receive a fee from that. So if I were to be one of these providers and I were going to offer a class in educational purposes, I could charge for that if I wish, and nobody intended to ever do business with me down the road as a debt management service agreement. I believe that's what we're intending to cover there, not the path on which you say where if you're going to do business with me, I've got to provide you this, and my fee will come when the service is provided. So I believe that's for an educational.
I'd just like to see some clarifying language, because
Sure.
I concur with the concept. I
Yes,
think it's a great concept. I'm just not sure if it says that.
Absolutely.
Representative Duncan?
Thank you, Mr. Chairman. Chairman Martin, quick question for you. Do you know what the position of the origination lenders are on this legislation?
I do not.
The bank's credit cards?
In terms, I know they wanted to be careful that the business that they entered into was not somehow regulated again, but I don't have any information I could share with you in terms of their position.
Okay, thank you.
Now, there was a sign-up sheet if anybody came in late that wanted to speak, but as of yet, I don't believe we have anybody in that group, Representative Duncan, speaking on the bill as a witness. Are there any other questions for Chairman Martin? That it? Chairman, thank you.
Mr. Chairman, if you don't mind, can I take a spot up here so
absolutely.
I can take some notes? Thank you, sir.
Yes, you're welcome to stay. At this point, I believe I'm going to recognize Commissioner Rob Braswell, Banking and Finance, to give his perspective on the bill and maybe a little bit of clarification on this, why we're here with a long bill, in a fairly quick period of time. We had some issues about governance and all of that we worked through.
That's correct. And thank you, Mr. Chairman. And I'm not sure about too much perspective, but I'm really here just to, as the department will be listed as the overseer or the supervisor, I wanted to state that we have no objection to us being placed as the regulator for this entity and this bill. This afternoon, while the House was still in session, the department's representative spoke with the authors of the bill. We do have some refinements now that we know that we will be the regulator if this passes. The refinements that we have agreed to, and of course that is not on paper before the committee today, but we have done that. Something that we would ask, the department is asking of the committee today, if there is a vote, we would ask that instead of this being placed under Title 18, it be placed under Chapter 1 of Title 7. That's the regulation or the code in which the department operates out of now. That's the code in which our general powers are in. and that also is the code that would provide more confidentiality protections for consumers, since we're talking about very sensitive information. And so basically, like I say, I'm here to state that we have no objection to being placed as a regulator over this industry, but we would ask that it be placed in Title VII, Chapter 1 of Title VII. That was agreed to as well by the authors of the bill.
Okay. I believe we can accommodate you on that,
Thank you. I appreciate that. Appreciate it, Mr. Chairman.
Commissioner. Okay, is there anything else you would have?
Not at this time.
Okay, thank you, Commissioner. While we're waiting, we'll hear from Brian Toney, American Fair Credit Council. Repeat your name and organization for the committee, just in case everybody wasn't.
Mr. Chairman, members of the committee, my name is Brian Tawney. I'm here on behalf of the American Fair Credit Council. We are a nonprofit trade association, national trade association for debt settlement companies, and we are here in support of the bill. You know, I think there's been a lot of questions about exactly what this bill will do and what it's aimed to cover. So I want to give a quick explanation of what exactly are the different types of debt relief services. I think that'll help frame the context a little bit better. I like to think of things visually. So if you imagine a sliding board, and at the top of the sliding board is a consumer that can afford to pay all their debts. They can pay everything. They can make all their payments on time. Coming down the sliding board, as a consumer needs more and more debt relief, you'd find consumer credit counseling. Consumer credit counseling is a service whereby the consumer talks with a counselor. They talk about their budget. Hey, you're spending too much money on you're eating out every month. You're spending too much money on entertainment. You need to focus on paying your debts. And that's really helpful for a lot of people. Those services are primarily provided by a nonprofit credit counseling company. As you come down, you have a debt management program. And a debt management program is for consumers with generally lower amounts of debt. And by lower, I mean usually less than $10,000. It's a program whereby the debt management company has an agreement in place with the consumer's creditors, whereby those consumers' creditors will reduce the interest rates payable to those creditors, and they will receive a payback over a period of 60 months generally, so about a 5-year payback. Some nonprofit credit counseling companies are paid not only by the consumer, but also by the credit card companies themselves by way of a method called fair share. It's a percentage of the amount of money they collect. Gets essentially kicked back to them from the credit card companies themselves. I've heard testimony in other states that these amounts could be as high as about 9% of what they collect goes back to them, in addition to collecting voluntary payments and other payments authorized by law directly from the consumer. Debt settlement is one notch down. Debt settlements for consumers that cannot afford to repay their debt. They need more than budgeting help. They need a very aggressive debt relief option that will help them get out of debt for what they can afford, not just what they owe. So a debt settlement plan doesn't just contemplate a reduction in interest rate. In fact, it doesn't contemplate that at all. It contemplates a reduction in the overall principal amount of the debt that's outstanding and owed. So this is a service, and consumers' credit can be harmed. It's harmed in a debt settlement program, and this bill makes it clear that the debt settlement company must disclose that to the consumer up front. It's an aggressive debt relief option. It's not for everybody. It's only for a certain amount of consumers. Typical programs are about 36 months in length, and the typical consumer will pay back their creditor around 45% of what's owed and then pay the debt settlement company their fee directly. Below that, The more aggressive debt relief option is obviously a Chapter 13 bankruptcy, again, another 5-year plan typically. And below that's a Chapter 7, a complete discharge. As far as the existing law that's on the books currently, it was written prior to the debt settlement industry really gaining popularity and really becoming an industry. In 2005, there was a federal law put on the books. It's called the Bankruptcy Abuse and Protection Acts, Consumer Protection Act. And what that did essentially is made it a lot tougher for consumers to qualify for bankruptcy protections, whether that be a Chapter 13 or a Chapter 7. Seeing the need for a more aggressive debt relief option, something between bankruptcy, which again was hard to qualify for, and a debt management program, which requires the entire repayment of the debt settlement industry came about 2005, whereas the current law in the books was drafted and put into effect and last revised in 2003. So the current law didn't even contemplate, understandably, the debt settlement market. The market wasn't around back then. The industry wasn't around back then. So what we've done now is, as an industry, there were some bad actors up front. And I'm sure you'll probably hear testimony from other speakers that'll come up here, and they'll say, hey, look, the debt settlement industry used to be fraught with players, or maybe they'll say it still is, fraught with players that would charge consumers an upfront fee in regard to agreeing to settle their debt at some future date. In 2010, the Federal Trade Commission came out and they passed a federal law. They actually amended the telephone sales rule, and what they said is the language that's in this bill. It's language directly from the federal government. They said no debt settlement company can collect a fee from a consumer until after the debt settlement company has negotiated the debt. They have talked to the consumer, and the consumer has to give them authorization to settle the debt. They have to have an agreement from the creditor to settle the debt, and at least one payment must be made towards that settlement. So what they've done is they've taken the FTC, they've taken the fee paradigm and they've shifted it. They've taken the control paradigm, they've shifted that. Everything is now in the hands of the consumer. You can bring them a fantastic settlement, maybe great settlement, 9 out of 10 people would take it. You've already done all your work as a debt settlement company up to and getting that settlement. It could be months of negotiation. The consumer can simply look at you and say, nah, thanks, but no thanks. I'm not willing to accept this settlement. It's totally up to them. So they have complete control. They can drop out at any time. They can cancel at any time. There's no termination fees. There's no penalties. And any money they put into the program, aside from the fees that have been earned, they get back. No questions asked. So there's no downside for the consumer as far as outlaying money and paying the debt settlement company prior to the debt settlement company fully performing. So all we're asking is we're supporting the bill in hopes that Georgia will take the same stance as about 31 other states, same stance as the federal government. Allow the consumers of the state to be able to utilize the debt settlement, debt relief option. This is currently unavailable to the consumers. The consumers are left with choosing between credit counseling and debt management programs and bankruptcy. It's a very, very difficult choice. All we're asking is that the debt settlement industry be allowed to conduct business in Georgia. In Texas, which this model law is based off of, they had about 145 registrants, to put it in perspective, right away. They've currently been enforcing this law, I believe it's been 2 years now, without any regulatory headache or any other problems. They've also allowed the service to extend to Texas consumers. In again, 31 other states regulate debt settlement like this, and we would like to see it regulated in Georgia as well. To quickly address Chairman Hill, a couple questions you had. The definition of a person is actually in line 58, where we've taken the step to define it as a corporation, a partnership, etc. So I believe that would address your first concern. Your second concern with regards to the $100 fee, as I indicated, under federal law, debt settlement companies are not allowed to charge any advance fees. So really what that $100 fee is geared towards is, as Chairman Martin was indicating, it's the credit counseling folks, the folks that provide the educational piece, and we'd be happy to work on language also with Chairman Martin in that regard. Representative Duncan, you asked how do creditors view the debt settlement industry. In 2009, which is the last time we actually ran a study on the level of debt our member companies settled, we settled over $1 billion in debt that year. So the credit card companies, I believe many of them are in favor of the debt settlement industry. They know it's a way they can collect money from the consumers. And we work not for the credit card companies, but for the consumers. But we end up returning them about 45 cents on the dollar, whereas a collection agency may only return about 20 or 30 cents on the dollar. So we're a more attractive option, I believe, to the original creditors than the collection agencies. In fact, We've, in the past 2 years or 3 years almost, since the Federal Trade Commission passed the law, we've developed a lot more inroads with collection agencies and debt buying companies because they see debt settlement companies as a real way for them to be able to settle debts en masse and in bulk. We can settle 1,000 debts at a time, whereas they'd have to call each consumer and work out a payment arrangement individually with them. So I think overall, particularly in the debt buying industry and the collection industry, we're viewed favorably. It's more so since the new law went into effect. Prior to 2010, when the fees were able to be charged up front, I think it was a different story. Right now, there are companies operating in the state of Georgia against the law. What they're doing is they're claiming they are an attorney model, and they're charging clients advance fees. It's happening, and I believe you could probably talk with the OCP, and I'm assuming they've probably had some complaints in that regard. Passing this bill, however, would let all the legitimate companies in. By letting the legitimate companies in, preventing the companies from staying here that are charging advance fees, you're basically weeding out the bad actors. It's the same thing the FTC rule did. So with that, I believe I've covered everything on my list. I guess there's no questions allowed. But with that, I thank you for your time, and I'm happy to discuss afterwards with anyone who has any additional questions.
Thank you, Mr. Tony. Ms. Jones?
Good evening. Thank you for everyone's time. My name is Michelle Jones. I'm the Senior Vice President of Counseling at Credibility, which is the local consumer credit counseling service of Greater Atlanta. We have been headquartered here in Atlanta, Georgia for 50 years. I have personally been working as a credit counselor or running credit counseling operations for 16 years, so I have a great deal of knowledge about credit counseling and how that works and how debt management plans, as they have traditionally been defined, work. So I'm hopeful that I can maybe add a little additional clarity there. I'm here today to speak in opposition of proposed House Bill 465. And as I think you've heard here today, while the bill repeatedly refers to debt management, it would in effect make debt settlement legal for the first time ever in the state of Georgia. And with all due respect to our previous speakers, I think that is indeed very bad for consumers. It's very bad for Georgia. It's very bad for business. In all the years that I have worked as a credit counselor, and I have two credit counselors here with me who work on this issue today, we have never spoken to a single consumer who has benefited from debt settlement. The structure of debt settlement is ultimately flawed when it comes to people in need. The analogy earlier of somebody going down the slide. The problem is when you're down at that point in the slide where you could potentially benefit from debt settlement, which on the surface sounds like a great idea. And I'll tell you, we in credit counseling have worked for years. We've talked with the Federal Trade Commission. We've talked with other counseling agencies. We've talked with the credit card issuers. We have tried to find a way to make debt settlement work. The reason that it doesn't work is because you have to have a lump sum of money available in order to satisfactorily or to settle a debt. People who are in financial distress don't have that lump sum available. If they did, they would be paying their bills. So instead what you do is you make a monthly payment to the debt settlement company who holds that in a trust account, waiting to amass enough to make an offer on one of the debts. As we've heard earlier, you make an offer on one of the debts and you're entitled to your fee, which as we've seen across the nation is 20 to 40% of the debt that's owed. Much more expensive than a credit counseling debt management plan, much more expensive than filing for bankruptcy. So you're amassing that money in the trust fund account, but what's happening in the interim is no payments are being sent out to the credit card issuer, and that's the problem. The credit card companies cannot agree in advance to a settlement. They can agree once you're ready to make the offer and make the payment, but they can't agree in advance and say, I'm willing to not take a payment for months and months while you save up your money. They are, due to their own regulatory bodies, required to continue with collections activity while that debt is sitting unpaid. So what happens is the consumer's sending the money to the settlement agency. They're holding that money. All the while collection activities are continuing by their creditors. It's taking months and months and months to save up enough to even make an offer on one of those debts. So collection activities continue. Interest rates go up to punitive levels, 30% easily. You're having late fees over the credit limit fees, and that doesn't go on for forever. It goes to collections. So your credit is even worse than it was when you started, which it was probably pretty bad when you started, but it's getting worse. It goes to collections, then ultimately you're sued because you're not making payments on your debts. You're sued here in the state of Georgia. We all know what that means. Your wages are about to be garnished. So now you're really backed into a corner, and you're at the point where you either have to accept a garnishment, so now forget making payments to the debt settlement company. You can't afford to accrue that anymore, or you have to go and file for bankruptcy. That is the story that we hear time after time after time. We just found out about this bill this weekend, and I admittedly have not had time to absorb all the pages of this, and I too was kind of looking for a redlined copy to see what's the difference, and it looks like it's a significant rewrite. But I sent out an email to my counseling staff this morning and said, hey, tell me your experiences about working with people who have tried to work through debt settlement. Within 30 minutes, my inbox was flooded. I have pages of feedback from my counselors. I have feedback from a counselor who previously worked in debt settlement, and she had grave concerns, and one of her lines was, I really hope you're able to stop this. It's a terrible thing. I appreciate that there is an attempt to put some controls into place to protect consumers, but to be quite honest, you can't protect against that fundamental problem that I just outlined, that issue of not having the money available immediately to make the payment. The other problem is that, as we said earlier, that fee being charged once you settle one debt. What we see at our credit counseling agency is typical client comes in with about $25,000 in unsecured debt. They are seriously upside down in their budget. They obviously have a terrible negative net worth. You look at that $25,000 in debt, well, there's easily a $500 medical bill in there somewhere. You settle that one $500 medical bill for, say, 50%, you can now take that entire fee that you have, quote unquote, negotiated with your client for the remainder of that debt, that $25,000 debt. That's just not, that's not consumer protection in my view. I went significantly off script. Just let me make sure that I made every point that I wanted to make here for everybody, because I think this is an important issue. You know, I guess just one thing that I would say here is I would just implore you to please slow this down a bit, to take a minute and take a look. If this is a good bill, if this is good legislation, if this is really true good protections for consumers, it'll stand up to the light of day. It'll stand up to having a little thought given to it, and I would encourage you to do that. You know, here in Georgia, we still have an employment that's above 9%. We still have a lot of people struggling to pay their bills, and I would really just encourage you to study this more carefully. That's all I have today.
Thank you.
Thank you.
Ms. Cole.
Thank you. I'm Liz Coyle. I'm Deputy Director of Georgia Watch. We're a consumer advocacy organization. We focus in the areas of health care, energy, and personal finance, and actually we find many of these are connected when we look at something like this. You know, I'm really actually very glad to speak with you today about a bill that will bring consumer protection to an industry that needs greater oversight, needs greater regulation. As you've heard in testimony just now, when people are in a situation that they might think they might need debt settlement, they're in a desperate state. And what this often leads to is a snowball effect, and they end up, through these practices, worse off than when they started. We believe that slowing down this bill is the right approach, and being careful so that, in fact, if you do enact something in this legislation, it truly brings protections to bear for consumers. There are a few things in particular that stood out to us in this draft of the legislation. Specifically, there do not appear to be any limits on the fees that could be charged. There are several different provisions in the bill that talk about when and how fees could be collected, but nothing that sets an overall cap on those fees. We're also particularly concerned that that fee can be collected after one settlement payment or one payment is made. and then they can collect all of the fee that they have negotiated. You know, at the end of the day, this appears to be providing greater opportunities, many of these services, in fact. At the end of the day, the consumer is left with some debt paid off. Maybe they're saving a quarter of that, but that other quarter then goes on to the debt settlement service. The actual model for debt settlement is to encourage consumers to go into default. And there are, as you know, many legal challenges associated with that. So while we absolutely applaud conversations around how to bring greater consumer protections into this industry, we hope that the next year will be taken to look into specific provisions in the bill that will add that protection and make sure there are no provisions in the bill that have unintended consequences of causing consumers to go deeper into debt and have greater legal troubles when they're finished with these services. Thank you.
Thank you. Mr. Hurt. And this is the final witness that has signed to speak on the bill.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. My name is Jimmy Hurt. I'm a consumer attorney and a business litigator. I practice out of Athens, Georgia. I will not reiterate the points that have been made, but our state statutes at OCGA 131 state that all interpretations of statutes, the courts should look diligently at the intention of our General Assembly, keeping in view at all times the old law, the evil, and the remedy. Now, going back to the 2003 Act, wherein the state created an opportunity for the debt management plan to go into place, the remedy was there was no regulations and fees were unregulated. And the General Assembly made it the public policy of the state of Georgia that unregulated fees in this industry were a huge problem and they needed to be regulated. And that's what was done. It was that act created a situation which was a win-win. The consumer got the credit counseling that they needed, and the creditors began to receive their payments, albeit maybe at a reduced level and a reduced interest rate. Creditors made some concessions. The debtor made some concessions by closing those accounts, not using them, and agreeing to pay them all off. And that's how the debt management plan operates. To allow debt settlement, we kick the door open. We do not now, we are violating the public policy, which we've already set, that we needed a cap on these fees. There's no longer a cap on those fees by allowing debt settlement. Not only that, but there's no benefit to the consumer because there's no protection. They're going to receive collection calls, collection lawsuits, garnishments if those lawsuits go through. And on the creditor side, according to the FDIC regulations, an original creditor has 180 days in which to charge off a default credit card. So after that first 6 months, that debt has to be charged off and it's sold to a distressed or junk debt buyer who pays 4 cents on the dollar on average for that debt. Now, the person that's going to benefit from a debt settlement is going to be the junk debt buyer, because now he is going to receive 50 cents on the dollar for something he paid 4 cents on the dollar for. The original creditor has had to take a complete business loss on it except for the 4 cents on the dollar that they sold the note for. So the benefit here is only going to the junk debt buyers and the debt settlement companies who have no cap on their fees. One other thing that I would like to point out specifically in the proposed act, and I apologize, I am working from I'm working from the previous version, not the one that was released today. There's a provision for arbitration in here. A debt management service agreement may contain a consumer arbitration provision. As I said, I'm a consumer protection attorney. I have seen many arbitration clauses in these agreements, these debt management agreements and in debt settlement agreements. These arbitration agreements are normally tied to a choice of forum and a choice of law. And there are always a foreign choice of law and a foreign forum selection clause, causing that already financial destitute consumer to have to either arbitrate or litigate their claims in a foreign court or foreign arbitration forum. Many of them are Texas, South Florida, California, and those particular provisions in that contract basically deprive that consumer of having any redress for a concern. I would say for seeking redress for anything under this act. I would suggest that the committee consider requiring the debt settlement company, debt management services company, to consent to personal jurisdiction and venue in the state of Georgia. If that were to be done, I would think that the arbitration provisions, if they choose to put one in there, would at least be somewhat more palatable. But the way these things are normally written, it's an interim clause. It prevents that consumer from seeking any redress whatsoever. Chairman Nix expressed concern about the lateness of the bill. I would like to reiterate that concern. I believe this bill does need additional study. During the session last year, there was an amendment sought through, I believe, this committee to the Debt Adjustment Act, and that bill ended up getting tabled. I had suggested to the bill sponsor that possibly there be a resolution passed for a study on this issue so that it could be addressed this session, and that was chosen not to be done. I would be happy to provide anyone that resolution about what a study would need to encompass to be able to provide information that this body could use to make a proper decision. My last comment would be there is essentially no difference between a bankruptcy and entering into a debt settlement plan. In a bankruptcy, the person, the debtor, stops paying their debts. They file the bankruptcy, the money is pooled within the bankruptcy trustee's estate, and the debts are settled through that bankruptcy proceeding. The benefits for the consumer in filing that bankruptcy is they cannot be sued, all actions are stayed, debt collection calls have to stop, no one can proceed with garnishment. It's the same scenario in debt settlement. The consumers reach the point they can't pay their bills. They begin to consolidate what assets they have. They negotiate with their creditors to attempt to settle these debts for the amount of money that the debtor has, but the protections under bankruptcy aren't there. They're not protected from suit, they're not protected from garnishment, and they're not protected from any dings on their credit. The derogatory credit entries will continue. Once the bankruptcy is over, then the person is working from a clean slate to rebuild their credit. Here they're looking at an uphill battle, attempting to rebuild their credit after going through a debt settlement plan. And the statistics from the federal and state officials show that less than 10% of all individuals who enter into a debt settlement plan actually complete it. Thank you.
Thank you, Mr. Hurt. Okay. I believe this is our posture. We have, I've heard some concerns from the committee members, what I take as concerns. We are going to have a vote. If we get a motion to have a vote. I'll point out that there's a rules committee. There is the possibility of this bill being an open rule bill that could be amended on the floor in some way. So you would have opportunities, presumably, to perfect this bill, not to mention our friends across the hall should we decide to send it over. So I believe that's our posture. Now let me see if I can correctly state the motion that we would need to move this bill out of committee. Based on my giving Commissioner Braswell my agreement that we would move to Title VII instead of 19 to better suit his department's structure in regulating this bill should it pass. So the motion would be to recommend a do pass by committee substitute by changing the language to reflect placing substitute in Chapter 1, or the wording in Chapter 1 of Title 7 instead of 19, and renumbering the language accordingly throughout the bill. That would be the motion if anyone wanted to make it. And you don't have to repeat it. You just have to say move.
So moved. Move the print.
Mr. Martin, you
Mr.
want
Chairman,
to address the committee?
well, if I may.
Yes.
If I may, and I will do it from here. I understand, there's some questions for the committee members, but I also, with respect to the speakers, think that we do provide more protections. Even if this were, if one were to decide that this didn't want to get into the debt management world, I think there are protections it would offer. If the committee would move the bill forward, I'm the primary sponsor along with three other folks on the bill. We're just pushed for time. If the committee would move the bill forward, we would continue to work on it. If you would work with me, I would commit to this committee that it's subject to your call and you're having time to work with me, that we would bring the legislation that we would move in the Senate back before this committee to a full hearing so that the committee could vet that language. But I just hate for us not to move forward with some language because, again, I show you a 3-page bill that does not regulate, in my mind, even the debt management services that are going on today. I believe you heard the speaker from Georgia Watch that thinks that there are protections in there that would be good, even if she would disagree that debt settlement were something that should be added. So to the extent that the chair wants to do that, you have my absolute commitment to
Excuse me.
a good consumer protection bill that would go forward. I'll leave it in the hands of the chair and the committee.
Thank you. I heard a motion do pass. Is there a second to the motion?
Move the print.
I'm recognizing this motion do pass. Is there a second?
That was not the motion was to accept the amendment. You're amending the bill, aren't you?
That was the motion that you were making, Mr. Hill?
I made it as you stated, Mr. Chairman, going forward.
Are you amending the bill, Mr.
Recommend do pass by committee substitute was what I read. Is that the motion that you made?
The motion I made, sir.
Is there a second? Second. I have a motion and a second.
Move to print.
All those in favor of the bill will signify by a raised hand. All those in favor of the motion, Mr. Hill. Raise your hand if you support the motion. Those who vote no on the motion, which is do pass. The committee has recommended a no pass for the bill. Thank you, committee members. Thank you for your questions. Thank you, witnesses, for all your participation. Committee's adjourned.